Thank you, Mr. Chairman, and thanks to our witnesses for their great work on this issue. Protecting intellectual property rests on a simple shared principle, and that is this: when people create something of value, their work requires protection. That principle is foundational to innovation, entrepreneurship, and economic growth, both here and at home. And lest we forget, Congress is specifically vested with authority under Article 1, Section 8 of the Constitution to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. During my time on Judiciary, I worked closely on this issue. In fact, Secretary Iancu and I worked a lot on several different issues as it relates to intellectual property that are imperative to defending U.S. innovators on the world stage and preventing the value of U.S. IP rights from being diminished outside of U.S. borders. This is something I think that's important across the aisle and certainly supported across the aisle. Director Iancu, when you were giving your opening statements, you happened to mention two bills that piqued my interest because they're my bills. You mentioned Restore Act and the Prevail Act. Restore Act being that provides for a rebuttable presumption that a patent holder is entitled to a permanent injunction against infringers after a final judgment finding that a valid patent has in fact been infringed. I think it's critically important, but I want you to tell those that are out there listening, why is it important for the Restore Act to be passed and for there to be this rebuttable presumption for permanent injunctions? Why is it important to American innovators?
Well, first of all, thank you, Congressman Moran, and thank you for your tremendous support and leadership when it comes to intellectual property protections in the U.S. and abroad, and in particular for your authorship of the Restore and Prevail Acts. You mentioned the U.S. Constitution and Article 1, Section 8, Clause 8, and there it talks about, as you indicated, exclusive rights. And by the way, the word right appears in the body of the Constitution, putting aside the Bill of Rights, appears once, and it's in this clause, in the Intellectual Property Clause. So when the Constitution talks about exclusive rights, it's difficult to understand how those exclusive rights can be enforced without the right to exclude. And unfortunately, in the United States, since the Supreme Court's decision in eBay v. Merck Exchange and the way the lower courts have interpreted it, it's almost impossible to obtain injunctions and exclude infringers. And this is really important for innovators to protect their inventions and to protect the domestic market from foreign infringement, any kind of infringement. And your Restore Act, it's a simple bill that would provide the constitutional exclusive right that inventors are entitled to.
Yeah, what do you think happens if patent holders don't have access in American courts to permanent injunctions to protect their IP? What happens on the world stage?
Exactly right. So if we don't lead here, other countries will follow suit, unfortunately. First of all, we definitely need to take care of our own home and protect our domestic markets from infringement, foreign and domestic. But when we don't take care of our own home, it's really difficult for us to advocate overseas to make sure that the other countries elevate, not depress, but elevate their IP protections.
Yeah, the Prevail Act, in addition to the Restore Act, the Prevail Act would set better standards for our PTAB system, help to reduce forum shopping, eliminate repetitious proceedings, ensure that that doesn't supplant the Article 3 courts that need to actually decide these things. It helps to revise the real parties and interest issues and closely align evidentiary standards and burdens of proof. It does all of that to, again, ensure that inventors are protected. And that's critically important, as you point out, because if we don't protect our inventors here and the patent holders here and innovation here, people are going to stop innovating. And then all of a sudden, we don't have anything to trade. We don't have anything to bargain. We are no longer the world leader in the economy on the world stage, because this is what makes America great: innovation and ingenuity. We must protect that. Secretary Iancu, I want to ask you this in closing. What countries out there are the least reciprocal in their treatment of intellectual property rights, and what action do you think, besides passing things like Restore and Prevail, do we need to take here in Congress?
Well, thank you, Congressman. The biggest offender of intellectual property rights remains China. and huge attention needs to remain on that. But in addition, as we've discussed throughout the day, we have our own trade partners in the West and otherwise that are pushing against intellectual property rights. I'll give you one example, and that comes with respect to standard essential patents. These are patents that protect standards-based technologies like 5, 6G, and so on. And countries like China, the European Union, and now the UK, they keep trying to take control of pricing of American patents and American innovation and lower the prices of our own innovation through their foreign legislation. The United States and the Trump administration has done a good job at pushing back against that, but they keep coming back in different forms, and we, the administration and Congress, needs to keep pushing back against those efforts to depress the price of American innovation.
Well, thanks for your work on this issue, Mr. Chairman. I yield back. The fight continues.